meeting to order. Agenda item 1, public access to meetings. This meeting is open for public attendance. You may also watch the meeting remotely via live stream. Agenda item 2, we have the meeting opening and roll call. Roll call and verification of quorum. Carlin, can you please call roll?
Ms. Erler.
Here.
Mr. Lepak.
Here.
Mr. Kowalski.
Here.
Mr. Pope.
Here.
Ms. Portson.
Here.
Mr. Robbie is excused. Mr. Shader is on his way. Mr. Summers.
Here.
Ms. Bushman.
Here.
We have a quorum.
Thank you. Agenda item 3, Pledge of Allegiance. If we could stand for the pledge, please. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, moving on to agenda item 4, public comments. Members of the public may provide comment pertaining only to specific items on the agenda in person or via email. Public comments on any notice agenda item will be presented during the public comment time of the agenda. Just a reminder that comments made by the public shall be civil in content and tone, affirming the decorum established for a school board meeting by the school board. Disparaging comments, remarks about school board members, employees, students, positions, position titles, and/or district citizens shall not be made. It looks like we have one comment. Did we get any emailed comments, Carlin?
We did not.
Okay, thank you. And then we have Leanne Stephanopoulos. If you want to please come up and, thank you.
Thank you for letting me speak. I just wrote up a few notes. I'm not a good public speaker, but I feel strongly on this one. I understand the meeting's being held to get the organization process in place to comply with the federal and state Title IX requirements to maintain our district funding. My question to all, but especially to you on the school board, is when do we say federal and state requirements have crossed a line that's harmful to the education and the environment of our students? 25 years ago, if this board or a school district had told parents we're going to let children as young as kindergarten decide their gender, not only are we going to let them decide their gender, we're going to affirm their gender. Parents and school districts would have been in an uproar. It would have been a line that was crossed, and I believe it would have been soundly rejected. These decisions have come over decades of dozens of decisions where we say to ourselves at home in group settings, that's crazy, this shouldn't be happening, surely this is a line that is crossed, but we've never stood up and said, okay, stop, this is too far. Decisions like no prayer in school, Bibles can't be used in school, even sometimes the Pledge of Allegiance, and now letting children decide if God, our Creator, made a mistake when He created them and their gender. That isn't too far. Our country, our community, and our children are yearning for a return to normal, sensible education. We're failing by allowing strings attached to our funding that dictate how we educate these children, the environment in which they learn, and for that I say shame on all of us. Have you decided what will be that true line? When will we cross that line? When will we say that this is too far? Will it be when sexual assault within the classroom is tolerated? Isn't that happening today with books presented to 8-year-olds? When parents can no longer have access to their children and what their children are being taught? Is it going to be okay when birth control is passed out to 10-year-olds? When are we going to say it's too far? I would submit that many lines have been crossed, and it's now time to say, no, this is too far. Strength of leadership by parents, community, and the school board is true service to our children. We need to take responsibility to lead our children's education. Are we going to take responsibility to lead our children's education, or are we going to turn it over to government officials in Washington or in Madison who blackmail us and blackmail the school district with funding and intimidation? I think this is too far. Thank you.
Thank you. Okay, let's move on to agenda item 5. We have a consent agenda. This includes employment recommendations, and that's it. So we are looking for a motion to approve the personnel recommendations as presented.
So moved.
Motion made by Meg,
Second.
Second by G. All in favor?
Aye.
Opposed? Okay, motion carries. Moving on to agenda item 6, board policy, we have 6A, Title IX informational presentation. And for that, we have Attorney Shayna Lewis, who's going to review some of the changes with us.
Good evening. The first thing I just want to make sure to say is that this is a challenging situation, and the question before you, the issue before you is challenging. You're hearing from a lot of different people, you're hearing a lot of different things, and you're hearing about a lot of things. Some of it has nothing to do with what you're doing tonight. Some of it is implicated. But I think it's really important to kind of figure out where we are, where we've been, and what the next steps may be. The first thing that we need to talk about is Title IX itself. Title IX is a federal law that was passed in the 70s. Title IX does not use terms like gender nonconforming, transgender. There's no reference to those terms within Title IX. Title IX essentially says at its very core is that discrimination on the basis of sex in educational institutions is prohibited. As a result of Title IX and that prohibition against the discrimination on the basis of sex, we also look to Title VII. Title VII is another law that was passed in the 1960s. And again, there's a long list of protected classes within Title VII, but one of them also is sex. And there's a prohibition against discrimination on the basis of sex in Title VII. We've looked over the years at the issue of what does it mean to discriminate against an individual on the basis of sex in employment under Title VII and in education under Title IX. And cases have been decided in various federal courts across the country and by our U.S. Supreme Court, both recently and historically. And over the years, there have been a lot of decisions that have interpreted or helped to identify what does a prohibition against the discrimination against an individual on the basis of sex mean. Because that statement alone needs to be interpreted and applied in real world situations. And that's what case law does. That's what court cases do, is it gives judges who are elected or appointed, who are trained as attorneys and typically as in prior judicial positions, it gives them the opportunity to look at historical information, at other cases, and issue decisions about what does the statute mean, that we are prohibiting discrimination on the basis of sex. If we look over time, one of the things that the court cases have done is they've identified what does it mean to have a sex that is then used as the basis for discrimination. If I treat you differently because you are a male, if I treat you differently because you are a female, those are pretty black and white situations. It's been expanded and interpreted further in a case from many years ago, the 1980s, Price Waterhouse, that discrimination on the basis of sex includes treating a female differently when the female doesn't conform to our stereotypes related to a female. What do we expect out of a female? And in Price Waterhouse, we're not dealing with a transgender individual. We're not dealing with a gender nonconforming individual in the sense that we're talking about now. We're dealing with a female in Price Waterhouse in that case who just simply did not meet the expectations that traditionally we had for females. And so the court explained that, yes, when we expect something different from a female, we are discriminating against them on the basis of sex if because we expect something different and they don't provide that, we treat them differently. Those kinds of cases have been issued repeatedly and have been reinforced both at the federal level and at our state level. Fast forward now to Title IX. Title IX started as a statute that helped to primarily equalize what we were spending and the resources we were providing to athletics, both for female students and male students. But it also included this prohibition on the basis of sex with regard to education itself. And to the extent that we were depriving males or females with the opportunity for participation in different educational programs or activities, that would have been a violation of Title IX. The Department of Education is the entity that is responsible for enforcing Title IX, and as a result, they promulgate regulations or rules. Those regulations have been in existence since nearly the very beginning. What rules are or what regulations are different than the law is that they get into more details. The law still just says that we are prohibiting discrimination in educational institutions on the basis of sex. And then the regulations flesh that out, explain what does that mean in the whole scheme of things. In 2020, the Department of Education, under President Trump, issued very detailed regulations concerning how we investigate and process complaints concerning sexual harassment and sexual assault. They were controversial at the time. They had nothing to do with transgender students or gender nonconforming students. They simply had to do with the issue of how we process the rules and with regard to complaints and procedures for investigations. Over time, there have been some concerns in application of those regulations, and one of the things that has been a goal of the Department of Education since then is to take the information that was shared with the Department of Education as school districts and higher education institutions have processed those complaints and investigations using those 2020 rules to make things better, to improve, to identify those areas where the rules did not serve the educational institutions properly. And so we find ourselves in 2024 with new regulations that primarily, if you look at the new regulations, 95% of the information in those new regulations address the concerns regarding how we process the investigations and complaints that are filed related to sex-based harassment and sexual assault that occur within our schools and within our educational institutions, programs, and activities. Now, that part of Title IX, the new regulations, it's not so controversial. That's not why we're here. That's not why people are here tonight. That's not why there's been a lot of litigation. There's 5% of the regulations that we're dealing with that do, in fact, take the term sex as we find it in Title IX, and from the federal law perspective, from the regulations perspective, they do something that the regulations had not done before, and that is take the term sex and expand the definition, flesh out, if you will, that definition. And the definition now includes references to gender identity, to sex stereotypes, and sexual orientation. That is the first time with these new regulations that we find those definitions within our regulations. And that's where the controversy is. That's where the concern is. That's where the litigation has been. And I want to make sure that we're clear on this. The majority of the Title IX regulations that changed the policy that you're going to be looking at tonight has to do with something totally different. It's about how you process those complaints and how you investigate those complaints relative to sex-based harassment and assault. But let's talk about that expanded definition of sex that we find in the regulations. And let's talk about the litigation that exists, including litigation that is pending right now before a district court in Kansas that specifically identifies the Stevens Point Area Public School District, really it's Stevens Point Area Public high school, or senior high school, in the actual pleadings itself. First, let's go back to 2017. Now, the new Title IX regulations, as I mentioned, we're dealing with the 2024 regulations. We had 2020 regulations before that that had nothing to do with this expanded definition of sex. But we did have transgender students attending school and requesting accommodations within the schools across the country, including here in Wisconsin. And we had litigation over the requests for accommodations and the refusals to provide the accommodations that were requested. And the famous case that we deal with here in Wisconsin, the one that we point to because it was decided by the Seventh Circuit Court of Appeals, which is the Court of Appeals that we're under the jurisdiction of, that we have to take our direction from. In the Kenosha Unified case involving a student with the last name of Whitaker, Whitaker filed a lawsuit under Title IX in 2000. It was actually, the decision was in 2017. So prior to any of what we're talking about here today. In 2017, the court issued a decision and asserted that without these regulations in existence, that they believe that Title IX's prohibition against discrimination on the basis of sex in educational institutions requires school districts to provide accommodations to students based on their gender identity and their transgender status or their gender nonconforming status. And in the Whitaker case, the Seventh Circuit Court of Appeals addressed pronouns, names, bathroom use, and participation in other activities and programs when you have a student who was assigned male at birth or was biologically male and who identifies as female or vice versa. And in the court case that was decided involving the Kenosha Unified School District, we got the direction from the Seventh Circuit that in Wisconsin, as well as in Indiana and Illinois, so the jurisdiction of the Seventh Circuit, we now have an obligation to accommodate transgender and gender nonconforming students as a means of not discriminating against them on the basis of sex. That's been the law here since 2017. And repeatedly, when school districts have refused in Wisconsin, in Illinois, and in Indiana, and litigation has ensued, the courts enforcing or interpreting the rights of those students keep referring back to the Whitaker case. And that Whitaker case has been cited across the country in several jurisdictions where the circuits agree with the Seventh Circuit, so where the judges in the other circuits agree. Now, I'm not going to pretend like there are not circuits, so courts of appeal in circuits across the country that disagree. We have right now a split in the circuits, and one might think that this is a prime opportunity for the United States Supreme Court to issue a decision. That's usually what happens when a split in the circuits regarding an important issue where people disagree, where students in one jurisdiction are treated differently than students in another jurisdiction, where the Supreme Court would issue its decision. And Corey has heard me say this before. The Supreme Court has had the chance to do this on several occasions. And for whatever reason, they've refused to do so. The cases have been appealed to them. They have had the opportunity, and in fact, in many cases, accepted the opportunity to issue a decision, only to decide that the case is moot when, surprise, the student who is at issue in the case graduates. Because that doesn't happen, right? We couldn't predict that. But that's not to bash the Supreme Court, but just to say that we could be here tonight, and I could be telling you that the U.S. Supreme Court has issued its decision, and the decision is whatever it is, and then I would be telling you that is what we would need to comply with in order to avoid being held liable in the event that we choose not to accommodate a transgender or gender nonconforming student's request for access to restrooms or locker rooms, use of pronouns, and names that are attributable to their gender identity. But I can't tell you that because we are sitting here today without a U.S. Supreme Court case. But what we do have is the Whitaker case. We have the Seventh Circuit case that has repeatedly been upheld. I say all of that because, as I mentioned before, 95% of the regulations that changed the policy that you're going to be looking at tonight have nothing to do with that issue. They just have to do with the complaint process and the investigation process that we use related to sex-based harassment and discrimination and sexual assault. But that 5% is really important because that 5% of those regulations actually do, in fact, take that definition of sex and make it very similar to what we've been using in Wisconsin because of the Whitaker case since just about 2017. And so we're here today talking about whether or not the school district should be adopting that policy and the purpose of doing so or not doing so. And what that purpose might be. If the purpose is to avoid that expanded definition of sex, I can tell you that that expanded definition of sex does not exist because of the regulations. It exists because of the Whitaker case that was decided again in 2017, 7 years ago. Now, I don't want to abandon the conversation that I alluded to about the existing federal court case in a district court in Kansas, because I think that's on everyone's mind. I think people are paying a lot of attention to it, especially given that there is a list that exists that was submitted late yesterday that includes your senior high school on the list of school districts. And I want to be careful with my words here. On the list of school districts where Moms for Liberty members send their children. I'm not saying where you are enjoined, and I'm going to get to that in just a second. So there's a court case that's pending in a district court in Kansas right now. District court meaning a federal district court in Kansas. We have 2 district courts here in Wisconsin. We have the Western District in Madison, the Eastern District in Milwaukee, and they serve our entire state. And then anything that is appealed from there goes to the Seventh Circuit, which is exactly what happened in the Whitaker case. So the district court in Kansas was dealing with a claim that was filed by a number of organizations, including the state of Kansas. So we had the state of Kansas, their Department of Education. We had the Moms for Liberty and a couple of other organizations that pursued a claim against the U.S. Department of Education, attempting to enjoin, to prevent the Department of Education from enforcing the Title IX regulations. They are pursuing that claim. They're pursuing that injunction. And they did not specify what portion of the regulations they wanted to enjoin. They just said, we'd like the Department of Education not to be able to enforce any of the new regulations. Their arguments, their publicity, the statements that they've made in their pleadings indicate that they are really concerned, not with the investigative procedures, not with the complaint procedures. They're concerned with the expansion of the definition of sex within those regulations. And so they pursued a preliminary injunction against the Department of Education. And on July 2nd, the the District Court in Kansas issued an injunction. And the injunction specifically prevents the Department of Education from enforcing the regulations, the new Title IX regulations. And I want to make sure I'm getting the language clear here. It enjoins the United States Department of Education and its secretary the United States Department of Justice, and the Attorney General, and all their respective officers, agents, employees, attorneys, and persons acting in concert or participation with them, from implementing, enacting, enforcing, or taking any action to enforce the final rule promulgated by the Department of Education titled Non-Discrimination on the Basis of Sex in Education Programs or Activities Receiving Federal Financial Assistance and published in the Federal Register. It specifically goes on to say that it enjoins them to the extent they are set to become effective on August 1st against Kansas, Alaska, Utah, Wyoming, the named plaintiff's school, the schools attended by the members of the Young America's Foundation. I'm sorry, I'm reading this wrong. Young America's Foundation or of Female Athletes United, as well as the schools attended by the children of the members of Moms for Liberty. And then it gives the organizations until yesterday to submit the schools which their members or their members' children attend. Now, I want to make sure that I'm clear with my language here. It enjoins the Department of Education and the Department of Justice from enforcing the regulations against those states that were identified, not including Wisconsin, and the schools attended by the members of the plaintiffs and then the members of those organizations. So it's the injunction is not against the schools, it's an injunction against the department, meaning that the department cannot hold those schools accountable if they fail to comply with the regulations. That's an important distinction. There is also a great question before the Kansas court that they have not issued an answer on, that the Department of Justice has appealed, has submitted an interlocutory appeal to request in part an answer about, from the 10th Circuit that covers them, to answer the question of whether a district court in Kansas has jurisdiction beyond those 4 states that were mentioned that are within the jurisdiction of the 10th Circuit. We don't have an answer there. So we're in kind of a holding pattern right now, but we are not under any injunction here in Stevens Point, even though your school, your high school, was listed as one of the schools where the Moms for Liberty members send their children. But there is nothing preventing you from doing anything. There's no obligation in this case to do anything, but there is an obligation in the regulations. Now, I wanted to talk very briefly about the consequences of failing to adopt this policy that is based on the obligations under the new regulations. First, I just want to say that in the event that you don't adopt the policy, as a result of the new regulations, that doesn't mean that you can avoid complying with the law. If you don't comply with the law, you are likely to be held responsible or liable under the law. If you fail to accommodate a transgender or gender nonconforming student in the spirit and the direction of what the 7th Circuit said in the Whitaker case, this injunction against the Department of Education in Kansas is not going to save you, is not going to be a defense. In fact, we won't be able to even mention it. It's not relevant because you're not a party to that case, and that case doesn't do anything against the district. It does something against the Department of Education. It just means you won't be held liable by the Department of Education. But our district court in the Eastern District or the Western District, wherever this case would be filed, or the 7th Circuit if it was appealed there, would hold you responsible to meet the requirements that were established under Whitaker. We also have to think about the other issues that exist Number one, it's just your high school who's listed in that injunction. Does that mean that we adopt a policy that applies to your grade schools, your middle schools, your junior high schools, but not your high school? That seems strange. That's one of the arguments that is being made right now to the 10th Circuit, that it makes no sense to have one school within a district or one school within a county be held kind of separate from the other schools in the area. We also have to think about the fact that there are other enforcement agencies. Our state agencies are not a party to this lawsuit at all. And our state agencies, the Department of Public Instruction and the Department of Justice in Wisconsin, which I mentioned the Department of Justice in that case, in that order, but that was the U.S. Department of Justice. Our Department of Justice is entirely separate. They could pursue a claim against the district relative to the failure to adopt the policy or hold you liable under the various other laws that apply and use as an example of your lack of accountability or lack of compliance, the failure to adopt this policy. But most important, it really is the liability associated with your individual employees and your students who were to assert rights under Title IX, not just your transgender and gender nonconforming students or employees, but your students who are victims of sexual assault or sexual harassment, or your students or staff members who are accused of sexual assault and sexual harassment. And both of those individuals, both categories of individuals, are entitled to the due process and very detailed requirements related to processing of those investigations and complaints that you would not be providing to them if you don't adopt the new policy. Now, I know that there's a lot of concern about the fact that perhaps this policy has gone too far, this regulation has gone too far, that perhaps we have to stand up to the different entities and agencies, and I do not begrudge anyone their political views, their religious views, their public perception, their public views on any of these issues, their political views. I do not also pretend that this is the law and this will always be the law. We recognize that with elections come changes to our executive branch, which the Department of Education is part of the executive branch, and we've watched that happen under President Obama, then President Trump, and President Biden. We've seen very big swings in terms of where we've gone with this issue, not to mention all of the other issues that those presidents have dealt with and have changed course on with each new election. And so it is very possible that you will go through this process and comply with the law as it exists on August 1st and adopt that policy. And then come January, February, you may have to take a different approach because we may get different direction from the Department of Education. But that's how it works. That's how the law works. We evolve, we change with the law, and we comply with the law as it exists today. And today, right now, there's a note on the Department of Education's website that explains that because of certain federal courts, including the District Court in Kansas, they are not planning to enforce the Title IX regulations in certain states. Wisconsin is not one of those states. And so right now, it is certainly up to you, school board. But right now, I can tell you that the law requires you to adopt the policy as revised in order to be compliant with the new Title IX regulations that were published in April of this year that go into effect on August 1st. And until we have a court of competent jurisdiction or a change in course by the Department of Education or Congress, it is very risky for the district not to proceed with adopting that policy. We've talked a lot about, in various groups, about what the options are. Certainly, your options are to proceed, adopt the policy, and then if something changes, you do what you've done in the past, which is you make a different decision in order to comply with the law. Your second option is not to proceed, is to keep your current policy the way that it is, which is not entirely compliant as of August 1st, at least that's what we believe is going to be the case. But again, just to make it clear, just because you don't adopt that policy, just because we just keep things the way that they are, you still have a legal obligation to accommodate transgender and gender nonconforming students in your schools, in accordance with the decision in Whitaker. Or the third option, and this third option is one that my partners and I, we represent school districts across the state. We represent school districts in urban areas and rural areas, in conservative areas and liberal areas, in very split areas. But what we are encouraging school boards to do, if they are uncomfortable proceeding with option number one, which is moving forward and adopting the policy, is to adopt the policy with a contingency. To essentially adopt the policy and say that we're approving this policy as presented, but that we are authorizing the administration to immediately rescind the policy or modify the policy if a court of competent jurisdiction or the Department of Education takes action to prohibit or modify enforcement. I'm going to stop talking now and see if there are any questions.
There's a lot to process. Thank you.
Very thorough.
Jim?
So I have a question. We received, I believe, all of the board members received an email from a constituent. Their concern was about athletic participation. I just want to clarify. My understanding is we as a district, we are subject to rules and regulations with respect to eligibility that are promulgated by the WIAA.
That is correct.
And so this policy, if we choose to adopt it, the reality is that the WIAA will continue to promulgate regulations with respect to student eligibility for participation. And that will continue, because if we do not comply in any way with what the WIAA requires, our students will not be allowed to participate. So I guess I'm just trying to clarify, in a certain sense, we as a board have no authority with respect to those eligibility requirements.
So,
And
yeah.
if we want our students to participate athletically, we will follow whatever the WIAA regulations are.
You are let me answer that question and so that we're clear. So number one, the Department of Education, in the new Title IX regulations that were issued in April of 2024, explicitly stated that there is no reference to athletics in these new regulations, that they intend to come out with new regulations at a later date. We don't know when that will be, and we don't know if it will happen given their historical approach to this. It could take a long time. In the meantime, we have the WIAA, which you are a member district of, that has their own rules relative to eligibility. And to the extent that you choose to do something that is contrary to the WIAA's rules, you are jeopardizing your school district's participation, and more importantly, your students' participation in WIAA-sanctioned athletics. The WIAA, based on a comparison of a lot of other organizations that we work with, they put forth rules and they enforce those rules. And that is something that I would be absolutely concerned about if it is important to this school board that their students continue to be able and eligible to participate in WIA-sanctioned athletics.
Thank you.
Jim?
My understanding on that WIA is they actually define under their ruling of what constitutes a gender identity, that you have to be under treatment hormonally for at least a year before you can be considered to be allowed to participate in a sport that's not consistent with your biological sex.
So their rules,
That is-
yeah.
And that is a distinction from, at least from the Title IX stuff, where there is not a distinction of you have to spend a year in treatment before you're considered.
So
You
the,
can change it, if you're like non-binary, you could change your gender hourly almost, right?
so Title IX does not say anything like
Right.
that. The regulations do not say anything
They don't
like that.
define it though.
They do not define it, that's true. And certainly to the extent that a family were to pursue a claim against a school district for violating their rights under Title IX, the initial discussion, and it was clear in Whitaker, the initial discussion is the demonstration that the student is in fact a member of that protected class, meaning that they are in fact transgender, or that they identify with a different gender than their biological sex or assigned sex at birth. And so while there is no obligation within the regulations to prove that, the same way as WIA has outlined a definition for how they will treat students based on their gender identity and whether they will consider them to be transgender, I don't see those as necessarily inconsistent. You can read those in harmony in that you are not necessarily accommodating a student who asserts that he or she is transgender and does not do anything in order to live as a different gender, to identify as a different gender. I can tell you, in working in school districts, I personally represent about 60 school districts across the state. My firm represents about 180 school districts across the state. I can't recall a situation where a family came out in favor of or in support of a child who was faking it in order to take advantage of something, or who was asserting a right based on something less than what we would consider to be a true gender identity.
Follow up to that, too, we say that it's not sports, but I think that specifically sports participation, at least what I've read, it actually says extracurricular activities is included. Does that, does that not include sports then?
Title IX does specifically reference curricular and extracurricular activities as areas where you cannot prohibit, or where you cannot discriminate on the basis of sex,
Right.
where you have an obligation to prohibit discrimination on the basis of sex.
So they're saying it's not sports, but yet extracurriculars are sports.
Title IX applies to sports, absolutely,
So-
but the new regulations do not. Right?
Do you not see that as a logical inconsistency?
There are tons of other regulations. Okay, so just so we're
I know, I
clear.
just say,
Yeah,
it
so wait.
says extracurricular.
Yeah, so let me answer the question so that I'm being clear. The Title IX regulations are a much bigger book. There are many more pages than the pages that we're focusing on right now that address the changes that occurred as a result of the 2024 revisions. So there are other regulations that address athletics. For example, the whole equality in how much we spend and what resources we provide to athletics based on sex, based on making sure that all of our students have access to extracurricular activities. Those regulations weren't touched by these new regulations. We're not talking about that at all, not because they don't exist anymore and not because they're inconsistent, but because they haven't been revised.
Okay, Alex, yeah.
Where do I start? So, one, if I not be mistaken, Department of Education controls funding for special ed, and free and reduced lunch, and ESSER funds, I think, was one of those other things, and there were a few other, there were a number of, so I think last year we received about $11 million from the feds. Correct? ESSER funding has ended, so that's about $3 million. So it's about $8 million that we're talking about, ish. That doesn't include any litigious things, right? So I'm talking specifically funding. How much was our referendum?
14 million?
14 million for this 1 year, correct?
No, it was
Phased over.
over
2 years, okay. So the Department of Education in the last 40 years has never withheld funding from a district.
Absolutely true.
Correct.
Absolutely true.
So, and we have districts that are non-compliance because there's a list of them that are non-compliance, but Department of Education has never withheld funding,
Absolutely true.
correct?
Absolutely
So
true.
we are basing a decision, I'm just basing a decision on the Department of Education never withholding funding from a district, even when they are not in compliance. And with the quantity of litigation that's going on, and we also have the Whitaker case. I talked with another lawyer not associated with your organization, who also does educational law, and they said the Whitaker case was specifically bathrooms. That's what, and they represent, so the Wisconsin Institute for Law and Liberty is who I talked to.
Okay.
And they said it was specific to bathrooms, and that's it. So districts that go further went further on their own volition, not necessarily in accordance with what Whitaker said. So when we're talking about Whitaker, and you've referenced Whitaker a multitude of times, however, Whitaker was just bathrooms.
I don't agree with that, but
Okay.
I understand lawyers disagree all
Lawyers
the time.
disagree.
Yeah.
Right? That's why we have litigations. And so my question is this. So with Department of Education never withholding funding, with, according to a different organization, not yours, right? So I'm being very clear.
That's fine.
That Whitaker is specifically bathrooms with what the Seventh Court said, and their interpretation was bathrooms. And they were basing on Title VII and not Title IX, was what Will said.
Okay, that's not true, but that's.
Okay.
Okay.
And so my question is, what type of likelihoods are we talking?
Sure. Okay, so first thing, I just want to make sure that this is clear because I'm not sure that this is clear. I don't make a decision. I'm not making your decision. I will never, I've been your lawyer for many years. I never tell you what to do. I give you the information that is readily available, that we've researched, that we've collected, and I give you the consequences of your actions so that you understand what they are. So please understand that I am not advocating here. I am not speaking from my own personal views. I am giving you information that we've collected as a law firm, again, presenting to various different school districts across the state who will make different decisions across the state. So I just want to make sure that that's clear. Second of all, absolutely true. The Department of Education, the Department of Public Instruction, has never pulled funding, federal funding or state funding, based on noncompliance. Absolutely true. In fact, I spoke with Bob Butler. I didn't speak with him, excuse me. I spoke with someone who spoke with Bob Butler, someone from my firm, who talked with Bob Butler, who's the attorney for the Wisconsin Association of School Boards, and he is aware of at least one school district that never adopted the 2020 regulations, and they do not have a problem with their federal funding. Absolutely true. And so the question in terms of why would you go ahead and adopt this policy? What is the purpose? What is the likelihood of having your federal funding pulled? It's minimal. What is the likelihood of having litigation? I will tell you that it's definitely not minimal. It certainly, we are in a situation right now, we're in a very litigious society. My guess is that maybe not your district, maybe another district, but there is going to be a district that doesn't adopt the policy that is going to be sued by a group or groups of individuals who think that they must adopt the policy. There are going to be school districts who adopt the policy, who are likely to be sued by organizations who think they don't have the right to or shouldn't adopt the policy. We are in a situation right now that is the grayest of areas. We've been here before. Act 10 was a good example of when we've been here before, where anything you do comes with some risk of liability. But that is up to you to decide as to where your comfort level exists with regard to risk. And that's why I've tried to outline for you what I understand the law to be. It might be different than what our good friends at the Wisconsin Institute for Law and Liberty believe. It might be very different than what the American Swiss Civil Liberties Union says. I mean, they're really, we're in a situation right now where people are making arguments. And that is what litigation is all about. I'll say this again. I know I said this at the beginning. I wish I could stand here and tell you the U.S. Supreme Court tells us that this is exactly what we need to do. And when the U.S. Supreme Court tells us what we need to do, that is the law of the land, and that is what we follow. We don't have that here. And so my hope is that the information that I've shared with you, including answering your questions to the best of my ability, that you can then make an informed decision about what you, the people who have been entrusted to lead the school district in Stevens Point, what you need to do to feel comfortable with your actions and the position that you put yourself in and the school district in with adopting the policy, not adopting the policy, or taking a middle ground approach.
And then just one follow-up question. So, for instance, student A uses the wrong pronouns for someone. What's their First Amendment right of freedom of speech versus what is a Title IX issue?
That is a really good question. So, first of all, misgendering someone or using the wrong pronouns or using the wrong name if someone, it's called dead naming in some situations, any kind of intentional or inadvertent, if it happens once, if it happens a couple of times, most likely that is going to be dealt with the same way as we deal with everything else in a school environment. Discipline is teaching. Discipline is about helping kids understand that their actions may hurt people's feelings, that their statements may hurt people's feelings, and we try not to hurt people's feelings within the school environment. Students certainly have First Amendment rights. They absolutely have First Amendment rights. And those First Amendment rights are greater, actually, than our staff members' First Amendment rights when they walk onto school grounds. To the extent that someone is speaking in a way that is a matter of their own public concern, their perspective, and they're saying something about their personal views, most of the time, that's going to be perfectly fine. To the extent that it harms another student, to the extent that we use name calling, the same way as we would address a situation if someone used the N-word or if someone used another kind of a slur, there would be some teaching. And then there would be some discipline if it didn't stop. But we always, and I talk to your administrators periodically when they're struggling with some of those areas where people's rights butt up against each other. In many cases, we have to tolerate when someone says something that we don't like. And in some cases, when it is harmful, when it is discriminatory, when it rises to the level of harassment, severe or pervasive is the term that we're using, then the discipline is imposed and then it goes and then it's processed. I will tell you that under the new policies, as well as the old policies, we're using a severe and pervasive or severe and pervasive standard. What that means is if someone uses a term once, if someone doesn't use the right pronoun or the person's preferred pronoun, that's highly unlikely to result in disciplinary action, let alone some severe disciplinary action. But certainly we deal with, and your administrators can talk to you about the First Amendment issues that we deal with on a regular basis, especially in an election year, with students and with staff members.
Okay, G.
I had a question about the three options that you gave us. One to ratify, one to not ratify. Then the third one, I had a question about ratify with contingencies, but isn't that option moot? Because if we vote to ratify, things are going to happen in the future. And if something happens where the change is made, we're going to have to change anyway. So the contingencies really, to me, are moot. They're going to happen anyway. So why would we have three options? That's, I don't understand.
The third option is an automatic, so it would be rescinded automatically. In order to make changes now, you react, Neola, your policy company, reacts to changes in the law. They do a really good job of reacting quickly, but it's not automatic. And so if there's some concern about the automatic nature of the third option, that was why we presented the third option. But certainly, you have every right as a school board to change your mind.
Yeah, so, I mean, we're going to ask if we make a vote. The third option, to me, kind of muddies the water because it's really moot eventually anyway, depending on what happens in the near political future. So, I mean, having three options kind of.
Point of clarification to G's point. So I think the third option makes sense to me. And the reason why is we know that there's a preliminary injunction right now. We don't know what the ruling is on that injunction. If we make a policy and we decide today that we're going to move forward with the policy, and then there's a preliminary injunction and that changes course, what that contingency allows us to do, and please confirm if I'm correct in my understanding, is we don't have to hold a special meeting, right? We don't have to all come together, and we will not be out of compliance because the contingency's in place to protect us until we learn more or there's a ruling that kind of changes direction or course. Is that?
Am I correct in saying then that affords you immediacy?
Yes.
Protection.
Yeah, I understand what you're saying. But in my own mind, I'm still saying it'll change right away anyway, if it changes. If it doesn't change, we're all right, but if it does change, then we must change.
Correct. So,
And you're saying we need a board meeting to do that.
Correct. Another special meeting.
so I agree with G. I mean, I believe we need to make a decision. I mean, changes might not happen for another year. There could be other board members. I mean, I don't believe that we should turn over our decision, because this is an important decision, that we should turn that over. I believe that when those changes happen, it would behoove us all as a full board, whoever is on this board, to hear from our attorney again about exactly what it is we need to do to amend our policy and to allow our community to understand how we're amending our policy to bring it in compliance. And I appreciate that you brought up Act 10. I mean, Act 10 is a very, very uncomfortable law in our state, and it has been forever. And this district, a number of years ago, based on the changes made with Act 10, chose to comply. Wasn't necessarily well received. There were huge questions in this state about whether Act 10 was constitutional or not. And clearly, it's coming back. You know, it is coming back. But what this district did was comply with the law at the time. I mean, I'm a rule follower. I believe it's really
I think we all
important
are, right?
for us as a board to follow the rules. I think it's a message that we send to our staff. I think it's a message we send to our kids. If those rules change, then it's our responsibility to change with those rules, to set politics aside and comply with what the law is telling us, with what we are required to do. I mean, to me, we have a current policy that exists for our district that already substantively includes all of this. I mean, it's existing in our policy, in our non-discrimination policy. What we're adopting here tonight is no different than the rules that we as a district have chosen to work with kids. Because at the end of the day, our mission is to prepare each student to be successful.
Okay.
And the reality is that every day, I'm gonna share this. You know, when this came up as an issue, probably 6 or 7 years ago with respect to bathroom use, and I understand it's a very sensitive issue. I had a conversation with our principal at the time, John Vollendorf, and John said to me, you know what, Meg, we've been accommodating that for kids forever, for all different reasons. We have kids who are totally stressed in the huge environment of SPASH, who we allow to use our faculty bathroom. I mean, we work to make each child feel at home and comfortable. But we also work to recognize all of our kids. And to me, I just think it's important that we follow the rule tonight, that we adopt this policy, and if 6 months from now or a year from now, another administration tells us that we need to adopt a different policy, then we have, Shana, you come back and you explain it to us and you tell us what we're required to do. And I'm not saying you tell us how to vote, but you tell us what the law is, then we respect that.
Okay, I'd like to respond. So we heard from Shana, there's 3 options. 1, to proceed as is and approve the policy. 2, to do nothing and wait. And 3, really, which is to your point, a middle ground of still being compliant and adopting the policy, recognizing there's a preliminary injunction where we may hear a ruling as early as this week, maybe next week, that would change things. So in my mind, and I am an HR director at a Fortune 50 company, so I am all about compliance, but in my mind, to me, it makes best sense to ensure that we are compliant and that we are also being sensitive to some very timely rulings that may impact the decision we're making tonight, recognizing that this needs to be in place by August 1st. And today is July 16th. So to me, that if we didn't, Meg, we would, if there was a ruling and the injunction did include our district and we approved the policy tonight.
Our high school.
Well, I think you sent amended list, but are we sure it's only SPASH that's on the list?
SPASH is,
Okay.
yeah, SPASH is the only one that's on the list. The prior list included just a list of counties.
Okay.
But the court had asked for a list of districts, and so they supplemented. The counties came on Friday. The supplemented school district list came on Monday, yesterday. And so SPASH is the only
Okay.
school listed.
So should an injunction then come where it's going to impact SPASH, Meg, I'm just saying, should it come, well then we would have to hold another special meeting, ensure that we have a quorum to do so, and we would not be compliant.
Actually, I'm gonna, and you can correct me if I'm wrong, we would be enjoined from enforcement pending ultimate decision by the court. Because all that has happened
Well,
right now
Shana, could you please
is
answer?
there's a preliminary injunction. So what would happen is if we adopt.
Well, can we let Shana share what would happen? Thank you.
Yep.
So it depends on what the district court's order actually
what
says.
the ruling
If
is.
if the order specifically enjoins the school district from adopting the policy, then certainly we would have to be in compliance. I will tell you, and we talked about this issue as it related to all of the schools in your district. I mean, you'd have to perhaps make a decision as to whether you're comfortable with SPASH being excluded and the other schools being subjected to the policy. That's a question that we haven't tackled.
It must be for me. I
1,
believe.
2, 3, I think, yeah.
Yeah, are you saying then too, is that, and I think the list is probably not complete, because I know there are
I
lots
know there.
of people in our
I think
district.
it's what was
So,
submitted.
so
But
the,
it may have been what was submitted, I
Yeah,
agree, and part of that reason has to do with, I think the Moms for Liberty site is not particularly well set up, because it's not meant to be district by district, it's not meant to be, it's like counties, it's like a national organization. They have nothing in their infrastructure that prepared them for this sort of short notice, we gotta get every single school. And they've asked, I think they've asked for more time to truly give you the list of all the different specific schools. And I think they meant that it should be a school district. I think the only one on there that you're talking about is just the YAF student. That you're saying Stevens Point area senior high is just the,
no, I'm,
you haven't gotten a list for them?
well, the list isn't submitted to me, it's submitted to the
Or what,
court.
You haven't seen it?
No. Okay, so just so we're clear on what we're talking about, the court established a
Right.
responsibility that the two organizations needed to submit the list of schools where their members' children attended. And so they complied. On Friday, they submitted a list of counties. On Monday, they submitted a list of schools. I don't know if they're going to be given more time. I don't know if the interlocutory appeal to the 10th Circuit is going to usurp that. I don't know what is going to happen. At this point, the only school that is identified specifically related to your district is Spash. There are other schools within the state of Wisconsin that have been identified, both public and private schools, and so we'll see what happens with them.
I know there are.
Oh, I'm not disagreeing with you
a
that
lot
there
of
are
schools
members.
that have actually tabled this.
No, I'm not disagreeing with you. There are a lot of
Because of
school
the
districts
school
where Moms for Liberty have submitted letters that indicate that I am a member of Moms for Liberty and my child attends school here. We absolutely have seen that across the state.
Do you have any comment on the Texas case, the Carroll Independent School District, where the judge has said he's given people till the 19th to submit their briefs, and he is expecting to, he's indicating that he's going to put out a nationwide injunction on this. So have you read that? Are you looking at that?
Yeah, we're definitely looking at all that.
Comment on that?
The comment is that we're not sure what the jurisdiction is that he would have in order to do that. Certainly in Texas, the Texas district courts have done that before, and we've never had that litigated beyond the Texas court. There is no court of appeals, there is no U.S. Supreme Court case that says that an individual district court can issue a nationwide injunction. I will tell you, we dealt with that issue in Act 10 here in Wisconsin when a Dane County judge issued a decision, and the question was whether a Dane County judge could enjoin a state law for the entire state, and that was something we debated at that point. Funny enough, it's 2024. We've been a country for years, many years. We have not had a case that has specifically addressed that issue. Maybe it's time.
I saw data that said, put out what said, there's been 96 such occurrences where a district court judge has put out a nationwide injunction since 2001.
I'm not aware of that data that you're
Trump
referring
alone
to.
had 60-some.
Yeah, I'm not aware of the data that you're referring to. I'm not saying it's wrong. I'm telling you I'm not aware of the data that you're referring
The
to.
Hawaii, the district court out in Hawaii put a stop to the wall from Hawaii.
That's out of my knowledge base. I'm not going
This
to.
isn't something that's happened 96 times.
Okay.
Okay, so we have two, well, I don't know if it's Will or G, and then Ted. Yeah.
Okay, all right. Well, let's go in order. So, yeah, I think I'd be more comfortable having the board personally revisit this as opposed to an automatic thing, because my assumption is that if there are more decisions handed down, they might enjoin the whole regulation, they might enjoin part of the regulation, they could issue, our district court could say something, our court of appeals could say something. Like, there's so many uncertainties, and we have a meeting in two-ish weeks anyway. I would prefer if we have the ability to revisit this personally. That would make me feel more comfortable, because there might be more guidance, probably will be more guidance in a few weeks. So
And
that's my opinion.
And regardless, we would still have the ability to revisit.
Yeah.
You have to be done
Absolutely.
by August
Yeah.
1st, right? This has to
That's
be
when the
done.
regulations go into effect.
So regardless of option two or three, we would still have the ability to revisit. It would just ensure that we're in compliance, given whatever that ruling is, until we revisit it. I'm sorry.
Ted, go ahead. I mean.
Thank you, G. I think that the contingency is redundant, that this board is responsive enough to come back on short notice to address any new issue. I think that we just go for the vote, and the contingency, if something changes, if and when it changes, we can meet and discuss it and be up to date on what we're actually talking about.
I'm asking that we do two options. Three will muddy the waters, and we might have a three-way vote, which would be kind of different. My feeling is 1 and 3 are one and the same. And as Ted said, we could come back quickly, or we could just say, make the third option and the second option the vote. Because I really feel 3 is the same as 1, because we're going to have to comply anyway. Now, if your reason is immediacy, you know, okay, I'm fine with that, but I really think they're just the same thing, and I'm ready to call the question, unless somebody has some burning thing they need to say.
I think, Jim, did you have something?
Well, I want to know, it's a question on, because this comes with substantial amount of training that has to be done. What are our costs on that?
Our firm is offering that training on a complimentary basis to our clients. Yeah.
Thank you. Well, I'm going to call the question then, with those two options, because I don't know how to vote on 3 options.
So I want to address, so what we're going to ask the board to do is take action on 2 different things. The first is some edits, which you all saw in your board docs, to our existing policy, because if we were to get complaints that happened prior to August 1st, we would have to process those with the old policy. Any complaints that come forward after August 1st, the second action would be to adopt the new policy in compliance with the new regulations. Either way, I'm making the recommendation that we take action on this, either approve it as is, or I also like the contingency because I like the immediacy. If something is ordered, that we will be in compliant the minute that happens.
Well, how do we vote then?
You vote however you want.
So we would say option 1, option 2, or option 3?
No, someone makes a motion. It can be to adopt policy 2266 with the edits. We could take a vote on it, or the second is the new policy, and that would be with the contingencies.
What about the third?
That is the third.
There's only 2 action items.
Oh, I see what you're saying. Option 2 would be to do nothing.
Okay, so option 1. So I'm calling the question. Is that all right?
So just so it's clear,
Yeah,
I am not suggesting that you take the 3 options and everyone vote for one of the 3 options. As Corey just mentioned, this is no different than any other time where you take action. Someone makes a motion to do something. If it gets a second, then you vote on it. So there's no confusion, because you're absolutely right. If you were to try to have everyone take action on one of the options, that would be very confusing.
Did you have?
I'm just curious how the new rules or whatever, and what our current policy is, and how it would address like what happened in Sun Prairie. The Sun
I
Prairie.
called to question. We have to vote on that.
Well, someone needs to make a motion.
Yeah, there has been no motion on the
I make a motion
table.
to call to question.
Okay, so there's,
Make a motion for one of the, to make a motion to approve.
But don't we have to
policy.
vote on ending the discussion
Yeah,
first?
point of order. So
Yeah,
he did make a motion to call the question.
We do an immediate vote on whether
need
we
a
want to
second.
continue or
There
not.
was,
So I made the motion to do that.
Requires a 2/3 vote.
It what now?
For cloture, you have to have 2/3 vote.
2/3 vote. Right, Carla?
So I make the
Yep.
motion.
But we have to have a second.
I'm sorry, what are,
I make
wants
the
to
motion
close
to
discussion.
close the,
Closed debate.
okay.
I'd second that.
So do roll call
Carlin,
vote?
do you have that?
Okay,
You wanna-
roll call vote?
Yeah, sure. get a clean sheet. Okay. So we will start with Mr. Pope,
Yes.
Mr. Kowalski,
Yes.
Mr. Summers,
No.
Ms. Portson,
Yes.
Mr. Lepak,
No.
Mr. Shader,
Aye.
Ms. Erler,
Yes.
Mr. Robbie is excused, Ms. Bushman.
No.
5-3.
Is that
Two-thirds.
2/3,
2/3?
not
No.
2/3. Fails.
So I'm gonna ask the question, is anybody gonna say anything more tonight that's gonna change anybody's mind? Because if not, we're at the point, I think, where we're just talking to hear ourselves talk.
So just to recap, so it sounds, we keep talking about the three options, right? Option 1, proceed and approve as is. Option 2, do nothing. Option 3 is that contingency, which is the middle ground. We heard Corey's point that she does prefer that third option. I do feel like, I know you think it's
No, I'm
it's a moot
fine
point.
with that, but then that takes the place of option 1.
Right.
Correct.
So we have
It's
two options
whoever-
only.
I hear what you're saying.
Whoever makes the motion makes the motion that they want.
And if you
then
want to
we
know what
vote
my
it.
recommendation would be, it would be either to take the exact verbiage that Shayna said, or motion to adopt policy 2264 contingent upon the court not imposing the potential injunction on the district. And that's for the second action item, that's not
Right.
2266.
Can we handle the first
Yes,
one
sure.
first? I would like,
I just want a point of clarification. So if this court imposes that, does that necessarily mean that they have the authority to do so? And that we are required to comply with it? It's a court in Kansas. We are a court in Wisconsin. We are covered by our
District course.
Wisconsin court system. And so for me, I'm struggling with why we, in the state of Wisconsin, as a school board, are going to default to a ruling in Kansas that may or may not have any jurisdiction over us. For me, that's why I think we should pass the rule the way it is, and if that occurs, then we should have, because what's going to happen is then you're going to be interpreting this, your law firm is going to be interpreting this for all of the other Wisconsin schools who you are representing, and then you're going to have the ability to come back to us and provide us with your best legal advice. And for me, that's I just feel like that's the responsible thing to do, to hear what you say. And what I heard you say tonight is, you know, that this is something that is currently law and that we're required to comply, and that it may change, but
By the end of the week or next week, potentially.
well, or maybe 6 months from
Multiple
now or
times.
a
Right.
year from now,
Absolutely,
or maybe not.
right.
You know, I mean, what happens
this
if
covers
what
us.
happens if a month from now, a court in Oregon or a court in Texas says one of our policies isn't legal? I mean, are we gonna like change it? I don't think so. I mean, I hope not. I hope what we do as a board is we listen to advice and we pass a policy.
I think that's what we're
and
doing
if-
tonight.
But if it changes, we have our attorney come back and we
Okay,
adopt
so we
a
can vote on that.
policy.
So I think we keep repeating ourselves. So is there anything new that anyone would like to share? Or is there a motion on the table? Okay, Barb.
I would like to move to approve amendments to Board Policy 2266, non-discrimination on the basis of sex in education programs or activities as presented.
Second.
Okay, roll call vote, please.
well,
Sorry, discussion.
Discussion.
Sorry.
One question, this is for using Prior to
Aug 1.
August
Yes.
1st, correct? Not the post-August
Correct.
1st? I just
Yes.
Yes, okay,
qualifying
yes,
that.
yes.
Agenda item 6B.
It's the
Any other questions or,
prior to August 1 changes.
okay, roll call vote, please.
Ms. Portson?
Yes.
Ms. Erler?
Yes.
Mr. Kowalski?
Yes.
Mr. Summers?
Yes.
Mr. Lepak?
No.
Mr. Shader?
Aye.
Mr. Pope?
Yes.
Ms. Bushman?
Yes.
And motion carries.
Okay, so then we move to C, 6C, and this is new policy 2020-64, non-discrimination on the basis of sex in education programs or activities.
Can I make a motion to vote?
Sure.
I do.
To approve
To approve.
as
this,
presented?
yes, as
I will second
presented.
that motion.
Based on our third option.
Option O.
So
The,
The
my feeling is
contingency,
1 and 3 are the same, but I'm willing to stipulate that.
the contingency vote.
That's fine.
So that would be a motion to adopt policy 2020-64 contingent upon the court not imposing the potential injunction on the district.
I'm going to withdraw my second.
Okay, so that's a motion made by G. Is there a second?
Okay.
I
There's no
will make a
second.
motion to approve option 1, to
And
approve
do we have to,
the policy change as amended.
we have to,
So you can just say his motion failed or.
okay, so motion failed,
The
okay.
second.
Okay.
Say what you're gonna,
I'm going to make a motion to approve the policy as presented. Option 1, no contingency. And for our board to revisit the policy if we are required to, if we are provided with legal guidance that we are required to do so.
a second.
Okay, discussion? I just think this is ironic that we talk about ensuring that we're fully compliant at all times, and not having the contingency puts us in, at least, I mean, we can't say for how long, right? But there's that immediacy factor, and so I am not supportive, but
I can respect your comments on that, but I think we're responsive enough where we can come back and address it quickly.
We could address it in the August meeting if we need to.
with days of noncompliance. And I'm just saying, that's the irony there. Okay, any other comments?
And we can't omit just the part about sexual identity.
Sure. If you wanted to make a friendly amendment, the person who made the motion and the person who seconded would have to agree to that, but you certainly can offer a friendly amendment. I don't know if it
To the
would-
motion.
To the motion, yeah.
To Meg's motion.
Any other comments or questions? Okay, hearing none. Roll call vote, please.
Ms. Erler?
Yes.
Mr. Pope?
Yes.
Ms. Portson?
Yes.
Mr. Shader?
Aye.
Mr. Summers?
No.
Mr. Lepak?
No.
Mr. Kowalski?
Yes.
Ms. Bushman?
No.
And motion carries
Okay.
5-3.
Thank you. We will.
Thank you, Shayna.
Thank you, Shayna.
Thank you,
Yes, I
Shayna.
appreciate it.
Drive safe.
Safe travels.
Safe travels.
Thank you.
No storms on the way home.
No storms.
Okay, moving on to agenda item 7A, purchase approval for new Chromebooks. We have Brian Casey up here.
Good evening. I have a fairly straightforward matter to present to you tonight, and that is the purchase of over 1,100 Chromebooks for our students. I'm here because the amount of the purchase requires board approval. The funds are already budgeted for. This is not a new expenditure. This is a continuation of our plan for replacing Chromebooks. It diverges slightly from what we've done in the past because we used to lease large amounts of equipment. We lease 4,000 or 5,000 Chromebooks at a time and pay them off over 4 or 5 years. What we want to shift to now is buying Chromebooks every single year, about 1,100. And what that allows us to do is to be a little bit more nimble when it comes to changes in devices. So we're not committed to a device for 5 years. 5 years is very old when it comes to a piece of technology. If a change were to happen within 2 years, we could pivot to a new device or start getting that into the pipeline pretty soon. We went through the board-required procedures of issuing an RFP. And we did that to all of our known vendors that we've worked for with in the past, and also some new vendors. Got the information on Chromebooks from them, and on the basis of that, we're recommending the vendor Trafera. We've worked with them in the past. They had the best value, and when I say value, it's not just the cost of the device, it's also the warranty, and in this particular case, a 5-year accidental damage protection warranty, which allows us to run that device for 5 years. So we found that to be the best value for the district. And that's what we're recommending at a cost of $554 per device. And that amount would be, I think I have it on here.
Did you say 554?
$499.
I'm sorry, 454.
Correct?
Excuse me.
Okay.
That would be a total of $499,400 for the purchase this year. Next year, we probably would be back with a similar recommendation, depending on what happens with devices and vendors. I will gladly answer any questions you might have.
How long do you anticipate making another purchase like this?
Well, we would do it every year.
Oh, this is
So
gonna
instead of
be
like coming to you
ongoing.
every 3 or 4 years or 5 years and saying that we need 1.2 or $2 million, we're saying we have this in our budget and this is what we're going to spend every year. Every year we will have approximately $500,000 allocated to spend on replacing Chromebooks.
Thank you.
Jim?
And I remember when I talked to you, I can't remember all the specifics when I met with you in onboarding. You said we use the Chromebooks specifically because of their limitations, actually, for security reasons. Is that right?
They are definitely easier to lock down and manage as opposed to a Windows device or a fully functional laptop.
Are kids allowed to use their own ever? Their own laptop if they have their own? Do you allow that? Or is there a security reason not to?
No, they are allowed to. It's just very difficult. They don't have the same access to the same Wi-Fi. It's the guest Wi-Fi. They don't have printing. We can't support that at all. So if they can't get something to work, we can't support a private device. We're not going to go on there and try and troubleshoot. So it is the recommended option that every student bring their Chromebook that we are allowed to work on, and we can support them for whatever educational program they're trying to access.
Other questions?
I will make a motion to approve the purchase of 1,100 Chromebooks from the technology budget for the cost of $499,400.
Second.
Okay, second made by Ted, motion made by Meg. Questions, discussion? All in favor? Aye. Opposed? Okay, motion carries. Thank you,
Thank
Brian.
you.
Thanks,
Thanks,
Brian.
Brian.
Okay, moving on to the 8A, sorry. Future meetings, dates, and times. We have our next school board meeting, our regular school board meeting on August 12th, and then another regular school board meeting on September 9th. Just a reminder for everyone, committee meetings, the Ed Services Committee meets the first Monday of the month at 5:30 p.m., and Business and HR meets the first Monday of the month at 6:30 p.m. Regarding agenda item 9A, I'm looking for a motion to adjourn.
Quick question.
Sure.
Ed Services in September. I think I got an email on that, but I don't remember.
It's going to be the Tuesday.
It's on the
I thought
Tuesday
Oh, good.
instead of the
I didn't
Monday.
know
Because it's
that.
Labor Day.
Day.
Okay.
Yep.
Correct.
Just wanted to make sure I
There
read
was-
that right and got clarification here.
5:30.
Yeah, not
5:30,
5.
yeah.
Not show up the wrong time too.
And school board is at 6:30.
6.
So 6 p.m. school
to
board,
pick you up,
5:30 Ed Services, 6:30 Business Services. Okay.
And you all have a revised invite for that
Okay,
at services.
thank you.
For the correct time.
All right, so with that, I am looking for a motion to adjourn.
I'll be fishing.
So moved.
Second.
Okay, all in favor?
Aye.
Opposed? Okay, motion carries. Have a good evening.
Thanks, everyone. Have a good
Thanks,
evening.
everyone.
Thank you.
Thank you.
Really do that professionally.